Subcommittee on the Constitution and Civil Justice will come to order. Without objection, the chair is authorized to declare a recess at any time, and we will do our best to get through the markup of these two bills before the votes. If not, we will try to come back after the votes, immediately after the votes. Pursuant to notice, I now call up H.R. 1797 for purposes of markup. The clerk will report the bill.
H.R. 1797, to amend Title 18 United States Code to protect pain-capable unborn children in the District of Columbia and for other purposes. Without objection, the bill is considered as read and open for amendment at any point. I will begin recognizing myself and the ranking member for an opening statement. Abraham Lincoln called upon all of us to remember America's founding fathers and their, quote, enlightened belief that nothing stamped with the divine image and likeness was sent into the world to be trodden on or degraded and imbruted by its fellows. He reminded those he called posterity that when in the distant future some man, some factions, some interests should set up a doctrine that some were not entitled to life, liberty, and the pursuit of happiness, that their posterity, ladies and gentlemen, that's us, their posterity might look up again to the Declaration of Independence and take courage to renew the battle which their fathers began, unquote. Today we consider H.R. 1797, the District of Columbia Pain-Capable Unborn Child Protection Act. This bipartisan measure has more than 130 sponsors in the House of Representatives. It protects unborn children who can feel pain from being subjected to inhumane, torturous, late abortions in our nation's capital. The gruesome late-term abortions of unborn children who can feel pain is, in my opinion, the greatest human rights atrocity in the United States today. Indeed, in light of the horrors exposed by the trial of Dr. Kermit Gosnell and the reports of similar atrocities across the country, I will soon offer a manager's amendment to broaden the coverage of this legislation so that its provisions will apply nationwide. Medical science regarding the development of unborn babies and their capacity at various stages of growth has advanced very dramatically, demonstrating clearly that unborn children indeed experience pain. The biggest single hurdle to legislation like H.R. 1797 is that opponents deny unborn babies feel pain at all, as if somehow the ability to feel pain magically develops instantaneously as the child passes through the birth canal. This level of understanding might have been excused in earlier eras of human history. But the evidence available to us today is overwhelming. Unborn children have the capacity to experience pain at least by 20 weeks, and very likely substantially earlier. I will now enter into the record a 33-page summary of the dozens of studies worldwide confirming that unborn children feel pain by at least 20 weeks post-fertilization. This information is available at www.doctorsonfetalpain.org. And I would recommend that all the committee members, their staff, and members of the press review this site to get the most current evidence on unborn pain. H.R. 1797 regulates all forms of late abortions, each of them gruesome and painful. Babies are dismembered or they are chemically burned alive through saline abortions or some other painful and inhumane method. Most Americans think that late abortions are rare, but in fact they make up about 10% of abortions annually. The Gosnell grand jury reports that at just Dr. Gosnell's clinic alone, quote, over the years there were hundreds of snippings that murdered late-term babies. With an average of greater than 1.2 million abortions nationwide each year, there are about 120,000 late-term abortions annually, or more than 325 late-term abortions every day in America, the land of the free and the home of the brave. H.R. 1797 would protect unborn children who have reached 20 weeks development from abortions on the basis that such unborn children feel pain, providing for a limited exception where an abortion is necessary to save the life of the mother. There is no standard rule to provide that an unborn child receive anesthesia. And so in that respect, unborn children receive less legal protection from unnecessary cruelty than farm animals, which are protected under the Federal Humane Slaughter Act. I would urge all my colleagues to join me in supporting H.R. 1797 here today. In the name of humanity, I would hope we could at least agree that pain-capable unborn children must be protected from these torturous deaths nationwide. I would now recognize our ranking member of the Subcommittee on the Constitution and Civil Justice, Mr. Nadler of New York, for his opening statement.
Thank you, Mr. Chairman. We're back again today considering legislation that would curtail women's reproductive rights. I understand how personally important this is to some of my colleagues, and they are certainly entitled to their beliefs. But the many Americans who see the world very differently, including millions of women who value their personal autonomy, can be forgiven if this looks like just another battle in the perpetual Republican war on women. I accept that on this one we are going to have to agree to disagree. In this case, my colleagues appear, through the operation of the criminal code, to be trying to settle a scientific question on which there is real disagreement within the scientific field. That is an exercise of raw political power, not a dispassionate fact-finding. Apparently, fetuses feel pain at 20 weeks because Congress says so, not because the scientists have discovered so. At our hearing, we heard views from professionals that are in fact viewed by many in the field as outliers, not mainstream scientific thought. It is unfortunate that in this committee we do not have more complete hearings, where different views on these important scientific, public health, and human questions can be aired. But with hearings having 2 or 3 majority witnesses and the minority having only 1, the record must remain incomplete and very distorted. This is not a problem peculiar to this legislation or to this subcommittee, but the complexity of the issues and the way in which mainstream science again has been shunted aside and distorted speaks volumes. The bill as introduced would prohibit nearly all abortions beginning at 20 weeks. That, as every first-year law student will tell you, is facially unconstitutional. But who cares about the Constitution in this committee? Just recently, the U.S. Court of Appeals for the Ninth Circuit struck down an almost identical Arizona statute, saying, quote, "Since Roe v. Wade, the Supreme Court case law concerning the constitutional protection accorded women with respect to the decision whether to undergo an abortion has been unalterably clear regarding one basic point. A woman has a constitutional right to choose to terminate her pregnancy before the fetus is viable. A prohibition on the exercise of that right is per se unconstitutional." Close quote. Nonetheless, this bill would prohibit nearly all abortions, including those involving threats to a woman's health, those involved in cases of rape or incest, and where the woman may have become suicidal. Exceptions to protect a woman where her life and health are at risk are required throughout pregnancy, even post-viability if the bill is to be constitutional, but are not provided for in this bill. I hope that in addition to the many statements of concern we will hear today for fetuses, we can also hear a few kind words for women and their families. The bill as introduced would, as was the case in the last Congress, apply only to the residents of the District of Columbia. Today, the chairman will offer an amendment to expand it to the entire country. While I had previously objected to the singling out of the people of the District of Columbia, who are tax-paying Americans, who serve in our military, respond when one of us has an emergency requiring police, fire, or EMT services, and the congressional staff who make our work possible, I must now extend my objections on behalf of my constituents and the entire country. The amendment will also more than double the prison sentence from 2 to 5 years. That should teach anyone not to disagree with members of Congress on questions of science. This legislation represents an extreme view of the abortion question and is at odds with the science. That is why people in many states have firmly rejected it, including the people I represent. Just as it is an outrage for Congress to impose its will on the people of the district in this case, so too I will fight any such usurpation of the rights of my constituents. I would also note that this bill only prohibits abortion at 20 weeks. It says nothing about the welfare of the woman while she is pregnant, her need for extra care in a pregnancy with difficulties of the sort our witness Christy Zink recounted at our hearing, or the need for costly neonatal ICU care that our colleague from Texas so eloquently and movingly described. Is it really the position of this committee that once we tell the woman no, we are ready to leave her adrift without any assistance? I wonder whether I could ask the sponsor of this bill to co-sponsor my bill, H.R. 1975, the Pregnant Workers Fairness Act, which has been referred to our committee. Perhaps we could even hold a hearing to see how we can stop employers from mistreating pregnant women and taking away their livelihoods or putting their pregnancies at risk while they are pregnant. I hope that caring for the fetus does not end with the criminal code. I hope the sponsors of this bill won't desert these women when they need our help. I'm not going to sit here and debate the question of fetal pain, except to note that Dr. Anand, who was cited in the majority's witness testimony and who was called by the majority to testify before this subcommittee in 2005 on this subject, told us, I can quote, "I think the evidence for and against fetal pain is very uncertain at the present time. There is consensus in the medical and scientific research community that there is no possibility of pain perception in the first trimester. There is uncertainty in the second trimester." Close quote. The Journal of the American Medical Association concluded that, quote, "Evidence regarding the capacity for fetal pain is limited, but indicates that fetal perception of pain is unlikely before the third trimester." Close quote. The Royal Academy of Obstetricians and Gynecologists concluded, quote, "It can be concluded that the fetus cannot experience pain in any sense prior to 24 weeks gestation." Close quote. Are we really going to take sides in this scientific debate by jailing and bankrupting people who don't agree? Because this is what this bill will do. Similarly, the claim that an abortion is never necessary to protect a woman's health is simply not one that is widely held in the medical profession, and the idea that we should be enshrining these marginal views into the criminal code defies reason. I hope that my colleagues here today will at least agree that even if they don't want to approve an exception for rape or incest, a woman can become pregnant as a result of rape. I find it deeply disturbing that when it comes to issues like this, some people think there's nothing wrong with making families in crisis have the courage of members of Congress' convictions. That is just wrong. We've heard a lot about the Gosnell case, and I would like to address it at the outset. Dr. Gosnell is a criminal. He is going to jail, and deservedly so. Colleagues who were here at the time may recall that I actively supported passage of the Born Alive Infants Protection Act, which made it a crime to kill an infant once it is born alive. And I said at the time, killing an infant was already illegal everywhere, and even if the bill was duplicative and added nothing to the law, we supported it just to deny anyone the ability to lie and to imply that supporters of a right to choose an abortion support infanticide. But of course they do lie, and they do imply that anyway. That bill was not about abortion because it involved live births and affirmatively killing a newborn. It was about classic murder. Similarly, Dr. Gosnell's practice of snipping a newborn's spine following a live birth is clearly murder and obviously illegal. That's why he was convicted of murder. What the Gosnell case does not illustrate, no matter how many times activists insist it should, is anything regarding the practice of abortion generally. The fact that 40 years after Roe, it is hard to find another practitioner like Gosnell really speaks to the actual state of that practice. But let's not pretend. It is a tragedy for these women, and it is a disgrace that any medical practitioner should have acted in this manner and should have been allowed to do so for such a long period of time. I would urge my colleagues to think about the extent to which he represents the poor quality of healthcare services available in poorer communities. We should be working to provide high-quality health care to the uninsured, to make sure that the full range of health care services, including family planning services, that are available to people with money are available to the poor and uninsured as well. If that means funding a Planned Parenthood clinic in every neighborhood to put guys like Gosnell out of business, so be it. If it means closer regulation of the medical profession, so be it. If it means an end to the constant efforts by my Republican colleagues to limit the rights of injured payments to sue, so be it. But let's not pretend this is about the practice of abortion in America today. If it were, our prisons would be filled with Gosnells. I don't think any of my colleagues have stopped going to the dentist because one dentist in Oklahoma, was found to have infected thousands of patients. And I don't think we should outlaw abortions because a bad actor committed crimes against his patients. If we started legislating on the basis of the bad actors in every medical specialty, then dentistry, podiatry, and every other field of medicine would have been outlawed long ago. I urge my colleagues to reject this misguided, clearly wrong, clearly injurious to women's health, and clearly unconstitutional legislation. I urge my colleagues to remember their oath to the Constitution. Anyone who votes for this bill today is defying the courts and saying the courts are wrong in their interpretation of the Constitution, and that's not our prerogative to do unless we propose a constitutional amendment. To vote for a clearly unconstitutional bill is to violate our oaths. I hope nobody does that, and I yield back the balance of my time.
Thank you, Mr. Nadler. I have a manager's amendment at the desk, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1790.
Will you suspend, please? I apologize.
Oh, that's quite all right, Mr. Chairman. I am happy to be able to put in my comments, even though the full chairman of the committee may not be here as well. I want to join the ranking subcommittee member, Jerry Nadler, in his comments. And it seems to me that the law and science is not on the side of this proposal or the subcommittee chairman, with all due respect. There's a big problem. Not only do we have Roe v. Wade, but we have a Planned Parenthood versus Case. We have the 9th Arizona Circuit Court, issued May 21st, by the way. We have a state court decision in Arkansas. And the shocking thing about this proposal is that they don't even make any exception for rape or incest. Now, this is not only patently unconstitutional, but it is also inhumane in the extreme. On the science side, it has not been determined that the question of pain is certain. It is unresolved in our scientific community, and so in the absence of any medical experts that I know of on this committee, it is totally out of order for us to determine a medical question like this under the guise of acting as members of the very vital House Judiciary Committee. No good has ever come from an all-male committee deciding the law about a woman's body. This is not appropriate, and I close by citing the letter of 15 doctors, and I ask that, well, no, it's not 15, 4, 6, 8, 10 doctors who have determined that the Franks bill would deny women residing in the District of Columbia, and now of all things, we're going to apply it to every woman in the United States of America, that it would deny them safe and legal medical care, and would constitute governmental interference with the doctor-patient relationship. And the other letter that I ask unanimous consent to put in the record is from 15 national religious groups who oppose this ban on abortion care after 20 weeks. It ranges from Catholics for Choice, the Methodists, Unitarian Universalists, the Jewish Council for Public Affairs, and many others. Mr. Chairman, I ask unanimous consent that these two letters be made a part of this markup.
Without objection.
And I yield back the balance of my time, sir.
Thank you, Mr. Conyers. I have an amendment at the manager's amendment at the desk, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1797, offered by Mr. Franks of Arizona. Strike all after the enacting clause and insert the following.
Without objection, the manager's amendment is considered as read, and I recognize myself to explain the amendment. This manager's amendment expands the bill's coverage nationally and also simplifies the bill in several ways. The case of Kermit Gosnell shocked the sensibilities of millions of Americans. However, the crushing fact is that abortions on babies, just like the ones killed by Kermit Gosnell, have been happening hundreds of times, every day, every single day, for decades in America. Those who incomprehensibly call trying to change this a war on women overlook the fact that roughly half of these babies that are so torturously killed each day are just little tiny women. They also overlook the fact that no one abandons or has less respect for a woman than one who takes the life of her child, takes her money, and leaves her with the inevitable emotional consequences that follow. Let us not forget that had Dr. Kermit Gosnell painfully dismembered these babies before they had traveled down the birth canal only moments earlier, he would have, in many places nationwide, been performing an entirely legal procedure. If America truly understands that horrifying reality, hearts and minds and laws will change. To that end, this amendment makes technical changes that expand the coverage of the bill nationwide. At the same time, this manager's amendment simplifies the bill in several ways, namely by striking the civil lawsuit and reporting requirements in the bill. At this stage of the public debate, I think it best to keep the bill focused on the pain experienced by the unborn children and not allow that overriding and tragic reality to be distorted by ancillary issues. Beyond that, the manager's amendment increases the criminal penalty in the bill to up to 5 years in prison for those who would participate in a late-term abortion. And it adds one sentence at the end of finding number 5. It also contains a change to the definition of abortion to make it clear that it would not be prohibited for a doctor to induce early delivery of a viable infant if he does this with the intent of preserving the life or health of the child after live birth. This is sometimes done in order to ease health problems of the mother. Once the baby has reached the point at which he or she is capable of extended survival outside the womb. And I would urge all my colleagues to support this manager's amendment. Are there any amendments to the amendment?
Mr. Chairman?
Mr. Nadler?
I don't have any amendments, so I'd like to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I have a number of comments on this amendment, but first let me comment on some of what I just heard. No one has less respect for a woman than one who kills her fetus, I think I heard said a moment ago.
No, correction, her child.
All right,
Yeah.
That's the quote, her child, when it's unborn. I would disagree. I would say no one has less respect for a woman than one who thinks she is too stupid or immature to make the choice for herself in the often agonizing circumstances that lead to a choice of whether to terminate a pregnancy. No one has less respect for a woman than those who think the members of this committee have more intelligence and more knowledge of her circumstances so that we can make the decision for her. We know better. We have the moral right to make the decision. She doesn't. She is too stupid. She is too immature. She is too immoral to be trusted with the judgment. People who hold that opinion have very little respect for the woman. Let me go further. I oppose the substitute amendment. It expands the application of the bill from just the District of Columbia to the entire country. It was insulting to the District of Columbia to pick them out, but it is worse to subject the women of this country, the entire country, to this terrible, terrible bill that removes from them the ability to do what some of them think they must do and substitutes our judgment for theirs. The amendment more than doubles the prison sentence from 2 to 5 years. That's also a bad thing. The bill relies on the Commerce Clause. The majority has made a fetish of saying we have to say for every bill what constitutional clause Congress's power relies on. I had thought that my colleagues on the other side rejected the notion that the federal government could regulate the healthcare market via the Commerce Clause. I think I recall something about that when we debated the Affordable Care Act. I think I recall them saying that in front of the Supreme Court. Is it possible that the Commerce Clause only gives us the power to take away medical services, but not the power to provide them to people who need them? What happened to federalism and states' rights? Is there an exception for women's health and autonomy? I don't recall reading about that in the Constitution. Personally, I believe that the Commerce Clause does give Congress the authority to intervene in the healthcare market. I've always believed that. And while I think that this bill is a misguided use of that power, I hope it portends a new understanding of the Constitution by my colleagues. I hope so, but I don't believe so. I commend the chairman for removing the private right of action from this bill with this amendment. We have debated this provision and provisions like it for many years and in many different pieces of legislation. The idea that someone other than the woman, someone who may have no interest in providing the kind of medical assistance to the woman if she must carry the pregnancy to term, may sue to impose his will on her is outrageous. The list of people who could go to court to interfere with the woman's health care decisions was stunning. In addition to the woman, who presumably has consented to the procedure or is a victim of kidnapping and assault, any person who is a spouse, parent, sibling, or guardian, or a current or former licensed health care provider of that woman or the U.S. Attorney for the District of Columbia could sue. That means that someone who provided temporary nursing care to the woman years earlier, or a physician who had committed malpractice upon her, would have standing to go to court and dictate health care decisions. This bill makes no provision for the kind of care the woman might require, especially if there is a live birth. The interest and obligation in the woman's fate or that of the child she is carrying appear to extend no farther than prohibiting an abortion. Critical care in a prenatal ICU, long-term care for the child, care for the woman, whether or not there's a live birth, there's nothing in this bill. Once Congress says no, she's on her own. So while I strongly object to the underlying bill, I welcome this change in the manager's amendment. I hope that in future legislation we can also dispense with this type of provision. I must nonetheless oppose the amendment because it extends the bill to the entire country and to all the women who live outside the District of Columbia. I yield back.
Thank the gentleman. Who else seeks recognition?
Mr. Chairman.
Mr. Nadler? I'm sorry, Mr. Conyers, forgive me.
Mr. Chairman, I rise, of course, in opposition of extending a bill that I thought effectively proved should not apply to the citizens of the District of Columbia. And now at the next meeting, we find ourselves discussing a proposal that would apply it to every woman in the United States of America. I find this unreasonable, and of course it only magnifies the opposition that I had to it when it was applied, meant to apply to the women of the District of Columbia. And so the subject of abortion is extremely difficult especially when recommended or proposed by a physician, but even a woman in her own conscience, in her own private philosophy and belief in life makes the decision. It's extremely difficult, and every pregnancy is unique and different. Unfortunately, some women must face emotionally devastating decisions of this nature in the course of their pregnancy that require them to consider abortion as a health option. And so if this bill were to ever become law, which I have every confidence that it will not happen, but for us to merely be considering it in the very, to me, crude way that we are today and in the previous hearing, it would be the Congress showing that it is able to impose its will with respect to one of the greatest tragedies that women and their families may ever endure. And so I refer us back to a case in Arizona, Isaacson v. Horn, which just said this. We do have lawyers and people concerned with lawmaking here. And here's what it says. Since Roe versus Wade, the Supreme Court case concerning the constitutional protection accorded women with respect to the decision whether to undergo an abortion has been unalterably clear regarding one basic point. A woman has a constitutional right to choose to terminate her pregnancy before the fetus is viable. A prohibition on the exercise of that right is per se unconstitutional. The Constitution requires that there be an exception to any prohibition to protect a woman's life and health, even after viability. As the Supreme Court stated in Roe, and again I quote, with respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has both logical and biological justification. If the state is interested in protecting fetal life after viability, it may go as far as to proscribe abortion during that period, except when it is necessary to preserve the life and health of the mother. But H.R. 1797 goes so far as to explicitly state that even a risk of suicide is insufficient cause to allow a woman to end a pregnancy. I thank you, and I return any time that may be remaining.
Thank you, Mr. Conyers. Now recognize Mr. Jordan.
Thank you, Mr. Chairman. I appreciate you bringing this bill forward and frankly, strongly support the manager's amendment that you have offered. And I'll be brief. Just in response to the ranking member of the full committee and my friend, the former chairman from the great state of Michigan, as he was talking about the Ninth Circuit court case, I think it's important, if we get this passed, and this ultimately becomes law, of course it's going to be challenged. Every time we do anything on the life issue, it is always challenged in court. We understand how that process works. But I think it's important to remember one of the last big things we did on the life issue was the partial birth abortion bill, where every federal court that heard that case said it was unconstitutional until it got to the Supreme Court, where they said, no, it is constitutional to explicitly state, to use the former chairman's language, that this procedure is wrong and should not be allowed. And that, if we can get this done, we're going to save a lot of kids, as the chairman has said. But of course it's going to be challenged, but we don't know ultimately what that Supreme Court may say. And I think that's important, and again, I applaud the chairman's efforts on this legislation and the many years he has worked on this issue.
Thank you, Mr. Jordan. Are any others seek to strike the last word? If not, the question occurs on the amendment. Those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chairs, the ayes have it, and the amendment. Clerk will call the roll.
Mr. Franks?
Aye.
Mr. Franks votes aye. Mr. Jordan?
Yes.
Mr. Jordan votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Forbes? Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Mr. Nadler?
No.
Mr. Nadler votes no. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Scott? Mr. Scott votes no. Mr. Cohen? Mr. Deutsch? Mr. Deutsch votes no.
Clerk will report.
Mr. Chairman, 6 members voted aye, 4 members voted nay.
The ayes have it, and the amendment is agreed to. Are there any other amendments? If there are no further amendments to the amendment, and the question is on the manager's amendment.
Mr. Chairman,
proceed.
Mr. Chairman, might I move to strike the last word?
Gentleman is recognized.
Thank you, Mr. Chairman, and I do appreciate the years of efforts you've had on this issue. My friend from New York indicated the proposed law is unconstitutional, and obviously there's disagreement about that, and I'm sure on making it to the Supreme Court there would be disagreement on the Supreme Court itself. But what we should not have any disagreement over, especially after the testimony of a former abortion doctor about abortions after 20 weeks and the insertion into the womb of a clamp that clamps something large known to be a leg or an arm and then grips for all he's worth and then rips off a leg or an arm and continues until both arms and both legs are ripped off of the child, and then eventually grab the skull, and when you squeeze hard enough, a gel-like substance comes, and you know that you have just crushed the head. There should be no disagreement about this process being deconstitutional. When you destroy the constitution of a living being, a living human being in such a way, it brings me to appreciate all the more the effort of our chairman, and with that, I'll yield back.
Thank you. Gentleman from Ohio is recognized. Mr. Shabbat.
Mr. Chairman, I also move to strike the last word.
Gentleman is recognized.
Thank you. I'll be very brief. A couple of the gentlemen on the other side of the aisle mentioned health and suicide, a number of other health issues as needing an exception. I know that a lot of the amendments will probably be saved for the full committee's debate, but I just wanted to mention the testimony that we had heard recently from the doctor, the New York doctor who had performed 1,200 abortions during the course of his career, Dr. Anthony Levatino. And he said, I asked him the question, getting to this point of rape and health issues, et cetera, how many of those abortions that he performed were related to rape or health issues? And he indicated of the 1,200 abortions that he had done, 2 were due to a rape. And he estimated about 12 of the 1,200 were related to health issues, either of the unborn child or fetus, as some of our colleagues referred to it, but that living being that's growing inside the mother, either her health or his health or the mother's health. So 12 of 1,200 were because of health issues, and 2 were because of rape. The other, if my math is right, about 1,186 of them were performed on perfectly healthy unborn children and healthy mothers. So I think a lot of times the facts out there get distorted about how prevalent these exceptions that are oftentimes insisted upon as necessary in this legislation are the case. And that was from someone who, during a pretty considerable time in his career, did these things, horrific things. And, I believe in redemption, and I think for that doctor to come here on more than one occasion and to be very open about what he did and why he changed his attitude about it and why now he's pro-life and opposes abortion is pretty courageous on his part. So I'm certainly going to give him the benefit of the doubt at this point. But just wanted to make clear about how many exceptions, how many times we're talking about either rape or health issues. It's minuscule in comparison to the number of perfectly healthy babies whose lives are snuffed out every day in this country due to abortion. I yield back.
I thank the gentleman. Mr. Deutsch, you're recognized now for 5 minutes.
Thank you. Thank you, Mr. Chairman. First, I wonder whether we're so callous, this group of men sitting up here working on this legislation, that we would dismiss just 2 cases of rape and 12 cases where the health of the mother is an issue. That this is so seemingly irrelevant to the debate that there's no need for us to consider it from that one doctor in one situation. How many other cases of rape? How many other times where the health of the mother is relevant? Why I really don't understand how it is that we can be so dismissive of that. That's number one. Number two, the suggestion that, again, that this, as we sit here, this group of men would talk about the perfectly healthy mothers that are making these decisions without pausing for a moment to reflect what is so often a horrifically gut-wrenching decision that these women make. Let's remember that there are, and I don't know what the numbers are, I don't have statistics, but I can tell you that this is never an easy decision. And I can also tell you that there are so many examples of families. This is not a women's issue. This is a family issue. And those of us who care about this issue on our side are staunchly pro-family. And for us to take the position that a family, that a husband and wife who desperately wanted to get pregnant, who desperately wanted to have a family, find themselves in a position where, having finally tried and having finally been able to conceive and having experienced the great joy of learning that, find themselves in a position where a doctor's visit shows a deformity, shows organs of the fetus outside of the fetus, shows the potential risk to the woman. To discount that, to suggest that this is something that women are quick to do, is, frankly, as we sit here, this group of men, just too hard for, I think, a lot of people who watch this to take. I oppose the legislation, but more than that, I oppose the characterization that those of us who believe so strongly that the insertion of politics into this relationship, this most personal decision that families have to make in consultation with their physician, with their member of clergy, with the people whose opinions guide them, that for us to insert a role for politics in all of this, in what is for them, what has gone from perhaps the greatest exaltation they have felt, certainly as a married couple, to the depths of despair, learning that they found themselves in a situation that forced them to make this painful decision. It's just not what we should be doing. I know that this bill will come through this subcommittee, and I know that we'll have an opportunity to offer amendments in the full committee, and I thank the chairman for that. But I just hope that we will remember as this goes forward that it's not as simple as it's described, that we remember the pain that these families face so often when they find themselves forced to make this difficult decision, that we respect the role that their doctors and their clergy play in helping them to make that decision, and that we never take for granted that there may only be some number of rapes, some number of cases where the health of the mother is at issue, that every single one of those is relevant. Mr. Chairman, I appreciate the time. I oppose the bill, and I yield back.
Thank the gentleman. Who else seeks recognition? Mr. Scott?
Thank you, Mr. Chairman. I yield to the gentleman from New York.
I thank the gentleman for yielding. Mr. Chairman, I've already given my opinion as to the merits of the bill, and I'll not comment on that further. But I do want to comment on some of what Mr. Jordan said about constitutionality. In essence, what he said was, regardless of how constitutional the bill may look, regardless of the fact that it is clearly unconstitutional according to the interpretations of the Supreme Court and the other courts up to date, you never know. In effect, we should vote for the bill if we like it on the merits, because maybe the Supreme Court will reverse itself. That's essentially what he said. I just want to say that, yes.
What I said is, sometimes when we make predictions that something is unconstitutional, we're not always accurate.
You're reclaiming my time.
By the fact that every federal court who heard the partial birth abortion law said it was
reclaiming my time.
But the Supreme Court then said it was.
Reclaiming my time. I think I paraphrased you correctly. The Supreme Court.
I think I quoted you correctly.
I'm not saying you didn't. The Supreme Court doctrine on this is clear. The Ninth Circuit articulated that. And what people are saying is, in effect, the Supreme Court may change. And maybe it will. I doubt it, but maybe it will. And we should, relying on that possibility, pass the bill if we think it's good on the merits. I simply want to say that's very dangerous grounds. People criticize the administration, the current administration, for not enforcing for not defending in court the Defense of Marriage Act because they think it's unconstitutional. They're enforcing it, I think, but they're not defending it. If they didn't enforce it, the criticism would be greater. We have an oath to the Constitution, and it's always possible the court will change its mind. But where the current law is clear, what we're saying in effect is we should pass this bill. We should impose an obligation, not just an obligation, we should impose a jail sentence. We should impose a jail sentence on people for doing acts which are legal under current Supreme Court interpretation, and expect them to undertake the defense and hope that the Supreme Court changes it, in effect retroactively makes it illegal because we say so. It's very disturbing in general. I don't have a solid answer. I won't say we should never do it. But to pass legislation knowing that it's clearly unconstitutional under current Supreme Court interpretations, there's no ambiguity, but hope that the Supreme Court will change itself is a very dangerous thing to do, and a very questionable thing under our oaths to the Constitution. I yield back, and I thank the gentleman for yielding. I yield back to the gentleman.
Gentleman from Iowa is recognized.
Chair, I move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. There are a number of people here on this panel that were actively involved in the partial birth abortion legislation that took a long time to get constitutionally resolved. Among them are my friend from Ohio, Steve Shabbat. And I also am among those. I came along in the second round of that instead of the first round. But here's what I remember. I remember a Supreme Court identifying a couple areas that were a bit vague from the statute that prohibited partial birth abortion. We defined that act precisely, and congressional findings said that there's the life and the health of the mother were not of incident to that heinous act, that ghastly and ghoulish and gruesome act. Mr. Gomertz just described this component of the ghastly and ghoulish and gruesome act. And if this is a stage of protecting innocent unborn human life that the ban on partial birth abortion constitutionally became, I think I would identify that as that and say it mirrors the same thing. We are all obligated to take an oath to uphold the Constitution. The definition of the Constitution and our understanding of it does not reside with 9 Supreme Court justices. It resides within our understanding, our oath, and our conscience. And I would say also that the question that's not being raised here is the question that the President of the United States refused to answer at Saddleback when he was asked, when does life begin? The soon-to-be president said, that's above my pay grade. And in the first weeks of his presidency, in fact, the first 48 hours of his presidency, he decided that it was within his pay grade. And I know that the chairman of this subcommittee knows very well that decision that was made by the president. We have an obligation under equal protection to protect all persons. And there is a right of the human person that's being defended here in this hearing. And I look forward to this process as it moves forward. I thank the chairman for having the courage to lead this. And I would yield to the gentleman from Ohio who has lended so much to this debate and this argument.
I thank the gentleman for yielding, and again, I'll be brief. The gentleman mentioned the debate on partial birth abortion, and this debate went on for like 8 years. And as my colleague from Ohio mentioned, we were defeated at the federal district court level at each occasion. Then it went to the circuit courts where we also were defeated. Went all the way to the U.S. Supreme Court, and the Supreme Court reversed the lower courts on a 5-4 vote. And one of the bases for that reversal and the reason they upheld the ban on partial birth abortion was that they found, as this committee and ultimately the House of Representatives and the Congress of the United States found, based upon medical testimony at this hearing, in this particular committee, was that partial birth abortions were never medically necessary. And in fact, not only that, but they could be harmful to the mother. And I distinctly remember Dr. Anthony Levatino stating when he was describing, as our colleague from Texas described, Mr. Gomert before, about the gruesomeness of these procedures. The doctors talking about oftentimes when they put these instruments in the mother, they're doing it blindly. They can't see what's happening, and they're grabbing arms and legs and ripping them out. And oftentimes, not only, I mean, clearly that's harming that baby who started out alive at the beginning of that procedure and is dead by the time it's through, but they oftentimes perforate the uterus of the mother and can do serious harm to the woman who's undergoing that procedure as well. So I would argue that there's clear proof that these procedures can be medically dangerous to the woman, as well as always medically dangerous to the unborn child. And therefore, I think there's every reason to believe that this may very well ultimately be upheld by the highest court in this land. I thank the gentleman for yielding. I yield back.
And reclaiming my time, I thank the gentleman from Ohio for his statement. I completely associate myself with each word that he has said, and I yield back the balance of my time.
And I thank the gentleman. And are there any others who seek recognition? If not, a reporting quorum being present, the question is on reporting the bill as amended favorably to the full committee. Those in favor say aye.
Aye.
Those opposed?
No.
The ayes have it, and the bill as amended is ordered reported favorably to the full committee.
Recorded vote, please.
Recorded vote is requested. The clerk will call the roll.
Mr. Franks?
Aye.
Mr. Franks votes aye. Mr. Jordan?
Yes.
Mr. Jordan votes aye. Mr. Shabbat? Aye. Mr. Shabbat votes aye. Mr. Forbes? Mr. King? Aye. Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. DeSantis?
Thank you.
Mr. DeSantis votes aye. Mr. Nadler?
No.
Mr. Nadler votes no. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Scott?
No.
Mr. Scott votes no. Mr. Cohen? Mr. Deutsch? Mr. Deutsch votes no.
Clerk will report.
Mr. Chairman, 6 members voted aye, 4 members voted nay.
The ayes have it, and the bill as amended is reported favorably to the full committee. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 1944 for purposes of markup. The clerk will report the bill.
H.R. 1944, to protect private property rights, be it enacted by the Senate and the House of Representatives of the United States of America in Congress assembled. Section 1, short title, this act may be cited as the Private Property Rights Protection Act of 2013. Section 2, prohibition of eminent...
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself and the ranking member for an opening statement. The Private Property Rights Protection Act is needed to blunt the negative impact of the Supreme Court's decision in Kelo versus City of New London, which permits the use of eminent domain to take property from homeowners and small businesses and transfer it to others for private economic development. In Justice O'Connor's words, the Kelo decision pronounced that under, quote, the banner of economic development, all property is now vulnerable to be taken and transferred to another private owner, so long as it might be upgraded. Nothing is to prevent a statement from replacing any Motel 6 with a Ritz-Carlton, any home with a shopping center, or any farm with a factory, close quote. The Kelo decision was resoundingly criticized from across all quarters. In 2005, the House voted to express grave disapproval of the decision and overwhelmingly passed the Private Property Rights Protection Act with 376 members voting in favor and only 38 members voting against. Last Congress, the House once again passed this legislation, this time by voice vote. Unfortunately, the bill has not been taken up by the Senate. The Private Property Rights Protection Act prohibits states and localities that receive federal economic development funds from using eminent domain to take private property for economic development purposes. States and localities that use eminent domain for private economic development are ineligible to receive federal economic development funds for 2 fiscal years. Every day, local governments in search of more lucrative tax bases take property from homeowners, small businesses, churches, and farmers and give it to large corporations for private development. And federal law currently allows federal funds to be used to support such condemnations, encouraging this abuse nationwide. This bill will restore Americans' faith in their ability to own, build, and keep their property without fear that the government will take it and give it to someone else. And it will tell commercial developers that they should seek to obtain property through private negotiation, not by government force. Too many Americans have lost homes and small businesses to eminent domain abuse, forced to watch as private developers replace them with luxury condominiums and other, quote, upscale uses. Family farms have been wiped out by eminent domain to make way for shopping centers and big box stores. And churches generally entitled to tax-exempt status are often seized through eminent domain to be replaced by more lucrative private development. Unfortunately, it is usually the most vulnerable who suffer from economic development takings, as Justice Thomas observed in his dissenting opinion in Kelo. Quote, extending the concept of public purpose to encompass any economically beneficial goal guarantees that these losses will fall disproportionately on poor communities. Those communities are not only systematically less likely to put their lands to the highest and best social use, but are also the least politically powerful. The deferential standard this court has adopted for the public use clause encourages those citizens with disproportionate influence and power in the political process, including large corporations and development firms, to victimize the weak, close quote. We must restore the private rights protections that were erased from the Constitution by the Kelo decision. John Adams wrote over 200 years ago that, quote, property must be secured or liberty cannot exist, close quote. As long as the specter of condemnation hangs over all property, our liberty is threatened. I would urge my colleagues to support the Private Property Rights Protection Act. And with that, I would now recognize the ranking member of the subcommittee.
Mr. Chairman, I'd ask that you recognize the ranking member of the full committee first.
I would now recognize the ranking member of the full committee, Mr. Conyers.
Thank you, Chairman. In the wake of the Supreme Court decision in Kelo, I've been concerned that states and municipalities could use this decision to expand their power in eminent domain, expand their power, whether for the benefit of private parties or for public projects, to the detriment of those who are the least powerful, namely the poor, the elderly, and communities of color. While I believe that the power of eminent domain can and has been abused, particularly with respect to those lacking such economic or political power, I've come to conclude that for the time being, we should allow the states to craft responses rather than impose an awkward, one-size-fits-all federal legislative response. Why? Because it's important to note that in Kelo, the Supreme Court acknowledged that state courts may interpret their own eminent domain powers in a manner that is more protective of property rights. And I am also encouraged that no less than 43 states have followed that advice and taken steps to restrict their own powers of eminent domain to guard against abuse. Example, in 2006, Michigan voters approved an amendment to Michigan's Constitution to preclude takings for economic development or tax enhancement, among a number of other protections for property owners and tenants. Given the fact that our system of federalism appears to be working in this instance and that states are in consensus on the need to prevent abuse, I don't believe that federal intervention is necessary or appropriate at this time. Also, the bill's enforcement provisions are very troubling. For example, a jurisdiction found in violation of the measure would be stripped of all federal economic development funds for 2 years, which could possibly bankrupt that jurisdiction. Despite that draconian penalty, the actual property owner would get nothing. The bill doesn't even give the property owner the right to sue to stop the taking in the first place. A suit can only be brought after the property is taken. The Supreme Court has long held that when Congress attaches conditions to a state's acceptance of federal funds, the conditions must be set out unambiguously. This bill, however, fails to satisfy this requirement with respect to its definition of economic development funds, which would therefore could subject a jurisdiction to its punitive provisions. The Government Accountability Office testified in the last Congress about the difficulty of determining what qualifies an economic development program. The GAO also warned that the loss of federal funding to a state and local government could encompass highway trust funds, community development block grants, and other Department of Housing and Urban Development programs intended to assist vulnerable communities.
How many votes we got?
The recent sequester has further diminished the already shrinking federal funds that assist state and local governments, given all of the uncertainty that sequestration has cast over the viability of states. And finally, against this backdrop, we need to remember that eminent domain abuse has a long and shameful history of disproportionately impacting minority communities. Inner city neighborhoods that lacked institutional and political power were often designated as blighted areas slated for redevelopment through urban renewal programs. Properties were condemned and land turned over to private parties. In Detroit, Michigan, neighborhoods such as Poletown have experienced firsthand how eminent domain can destroy neighborhoods, presenting issues to those in Kelo. This underscores why it's important that we continue to monitor the facts on the ground to determine whether federal action is warranted. I thank you for this opportunity.
thank the ranking member. The ranking member of the subcommittee is recognized.
Yeah, Mr. Chairman, I see we have a vote on the floor, so I'll just ask, instead of delivering my opening statement, unanimous consent to insert it in the record.
I thank the gentleman, and without objection, that will be put in the record. Anyone wishing to make a comment or amendment to H.R. 1944? If not, we'll call up the bill for a vote. All those in favor of H.R. 1944 will signify by saying aye. Aye. Those opposed?
No.
In the opinion of the chairs, the ayes have it. Recorded vote being asked for. Clerk, call the roll.
Mr. Franks? Mr. Jordan?
Yes.
Mr. Jordan votes aye. Mr. Shabbat? Aye. Mr. Shabbat votes aye. Mr. Forbes? Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Mr. Nadler?
No.
Mr. Nadler votes no. Mr. Conyers? No. Mr. Conyers votes no. Mr. Scott? No. Mr. Scott votes no. Mr. Cohen? Mr. Deutsch?
Clerk will give the tally.
Mr. Chairman, 5 members voted aye, 3 members voted nay.
All right, the bill has sufficient votes to pass. Without objection, the bill will be reported as bill wasn't amended. Bill will be reported as introduced, and staff is authorized to making technical and conforming changes. And with no further business, we're adjourned. Thank you.